questions that you have or concerns you have about the quiz, or?
So I haven't gotten to Friday's videos yet, but in regards to the videos where you had the interviews with the realtor and the attorney, do we need to know specifics about that flow for the quiz coming up?
So that's more so to provide you a background so that you can do Friday's work. So I know it seems like when you were listening to it, it didn't seem like you were doing, because we didn't talk about cases or anything like that, but we talked a lot about notice, race notice. So in the videos for Friday, I kind of refer to that, that interview kind of for context. So I say, we talked about how North Carolina is a race state, right? So that interview will make more sense after you watch Friday's material.
Gotcha.
And you may honestly even want to go back and listen to that interview after you watch Friday's material, because it might help reinforce your understanding of the process. Because I think where it's helpful is, here, let me see if this is going to work. We're going to try to put you. So I think where it's helpful is that it helps you understand the process that is used to search title. Okay. Sorry. Can you see the PowerPoint screen on? Or no?
I just see a white screen right now. I don't know if that's what it is.
Oh, yeah. Woohoo, it worked. Okay, so let me show you what I mean. So I talk a lot with Barbara about, what she does when she gets a case and what she searches for, what types of things that she looks for, what are some scenarios that she had, like the Baker Barker situation, for example. That's all going to make more sense once you start doing the problems on chain of title and recording and stuff like that. So if you go back and listen to it later, you might be like, oh, okay. So it's just supposed to reinforce the material. There's actually nothing new in there that isn't in your book, except for a little bit of the wills stuff, and that you can kind of disregard.
Okay, thank you. And I'm looking at my notes now, so I might have another question.
That's fine, no problem. Okay. All right, let's see. Okay, anybody else have any questions while I try to figure this out? No questions? None whatsoever. All right, well, then I'll just talk. I didn't prepare anything because, frankly, I don't know what areas to clear up for you all. I think, so the seller's material is going to be on the quiz. And I think it'll be pretty clear to you once you get into Friday's lecture what material is most likely going to be on the multiple choice. Right, so it should be pretty clear to you. You can expect some of the chain of title questions, some of the race versus notice versus race notice jurisdictions. This is going to work as well as I wanted it to. Oh, that was a good idea. Well, hey, it worked. All right. Right. So race notice jurisdiction. So we have the race jurisdiction, we have the notice, we have the race notice. Expect some questions on that. you can expect some questions on, let's see, let me look through the chapter. So it's technically, this is a question and answer session. There are no questions. I'm well within my power to just play 80s music for the next 30 minutes, but okay. So things to watch out for. We have the statute of fraud, okay, in this chapter. You're going to want to understand what marketable title is. You're going to want to understand equitable conversion. And you're also going to want to know the different rules as far as who bears the risk. So there are, if you look at Brush, it lists 3 rules. Probably a good idea to know those, because I made a comment on all your quizzes last time that, you know, it's going to be important to know not only the majority rule, but the minority rules as well. And so in the question, because these are multiple choice, it'll state in the question what rule applies. So you're going to want to know that. They're going to be time crunched again. And the reason that I'm doing a time crunch is because if you all have too much time, then you are more likely to be able to locate the answers in your book. So that's a little tip that you should know, to be making sure you study what's in your book. All right, so continuing with chapter 8, you're going to want to know the duty to disclose, the differences between the common law approach versus the majority approach. And thank you to Jacob for catching my having uploaded the wrong video. You all would have thought of a different approach. Let's see what else. And I already mentioned this, make sure to pay particular attention to the hypotheticals in your book. I would also try to make connections between the different topics in the various chapters. So at this point, we've looked at things like, or at least different sections, we looked at things like an implied warranty, right, of habitability. How does that differ from some of the other concepts we've looked at in this chapter, right? And a hint is that a lot of times the difference has to do with when, at what point in the process are you at, as to which of the doctrines can be invoked. I don't know what these buttons are on. Let's give this a try. I introduced in your Friday videos some different ways you can diagram chains of title. I strongly recommend that you find a way that works for you, and you, as soon as you get a complex fact pattern, you diagram it out so you can keep track of when things happened. And it might be a good idea to have near you a different color pencils or highlighters so that you can make sure that you highlight when things are recorded on the timeline. I also personally, so when we talk about notice, which is in today's material, when we talk about whether or not somebody or who has the superior title, right? So if somebody fails to record, what happens? Who has a superior right to title? And we discussed that there are these three different types of jurisdictions, different statutes, and that you might get different results if you apply these different statutes. And what you'll notice is the key to the notice statutes is that whether or not somebody could have been on constructive notice, because to be a bona fide purchaser, you'll have had to have had no constructive notice or no actual notice, okay? And I didn't specify this in the video, but the reason why you might want to diagram the conveyances or the chain of titles in different ways or find a way that works for you is because when you're talking about constructive notice, the court is really asking if the subsequent purchaser did a record search or did a little bit of investigation, could he or she have found the previous title? Okay. So to determine that, you're going to need to try to envision what the recording system has in it, all right? So what do I mean by that? Well, let's say that B transfers the property to C. C doesn't record. Okay? Then B forgets that they transfer it to C, and then they transfer it to D. Okay? And D doesn't record. Right? So who has claim at this point? Well, that depends on which type of jurisdiction you have, which of these. Let's complicate matters a little bit further, and let's say D sells it to another party. And then let's say that then S decides that they're going to record. All right, and then it's not until then that S records. Okay, you can see how it gets complicated here. Now, this type of diagram gives you an idea of the timeline, right? So we have these numbers here that are telling you the order that this all happens in. And then I tell you in the video, I use red or a different color or a symbol that says, hey, it was recorded here. And so if you were just in a pure race jurisdiction, that means whoever records first, which North Carolina is, you may remember from the video interview, right? So I talked to Barbara about this. And in North Carolina, it's whomever records first has the title. So in North Carolina, or in a pure race state, it would be C that gets the title. In a notice state, the court would ask, well, we have a bona fide purchaser, okay? And a bona fide purchaser is somebody who paid value and didn't have constructive or actual notice. So to figure out the actual notice, you say, did they actually know about the previous transfers? For constructive notice, though, you're going to have to figure out if, let's say, we're talking about S here. If S goes to the recorder's office and did a title search, would they have found the previous conveyances? And you might not be able to tell that from this right here, this diagram. So another way to do it, another way to draw it would be to say, okay, B made a conveyance to C, B made a conveyance to D, right? Then D made a conveyance to S. Now, your book and the majority of jurisdiction use what's called a grantor or grantee index, which means that the way you do a title search is that you are going to take, so let me rephrase, the way the recorder's office indexes titles is by the name of the grantor, not by the property number, which is really weird to me because I practiced in Nevada, and in Nevada you put in the property, the parcel number, and everything that is attached to the parcel number pops up, and so you don't have these problems. However, apparently in most states they don't do like they do in the Southwest, and they have everything indexed by grantor name. So you have to, so let's say you're an attorney and you're going to the title office to do a title search. I know Barbara said she doesn't do her own title searches. When I practiced, I didn't do, we didn't do our own, we didn't pull the title. We paid a title company and they had databases on top of the recorder's office, and we pay them, they'd give us a report and we'd analyze the report. So, but these folks, they used to be attorneys that would go down to the office to see, okay, is there a good title that's being conveyed, right? So if S or S's attorney goes to the recorder's office, they're going to take a look at the conveyance from D, and then they're going to try to figure out, well, who did D get the property from? They got it from B, and they're going to say, okay, this all looks good. B, let's say B gave a fee simple to D, D gave a fee simple to S. They're going to look to see if there's any liens here, if there's any encumbrances over here listed on the deeds. This is the chain of title that they're going to check. But as you can see here, we can't expect S to have notice of C's interest, even if C had recorded. Why is that? Well, because let's say C records here. C records here. What do I mean by that? Well, they obviously record after S takes the property. Because if they recorded before S took the property, it would have popped up in S's search, right? So if, let's erase this and start this again. This is what Barbara was trying to explain. So if, and that's why she was saying, I go and I search multiple times to make sure nothing has been recorded, and I search right up until we execute the documents, and that's because it's a race jurisdiction, so whoever records first gets the title. In a notice jurisdiction, the court asks, could they have had constructive notice? And they could have only had constructive notice if a conveyance that was properly acknowledged and met all the formalities was recorded before they purchased. So again, we have B conveying to C, B conveying to D, then conveying to S. S starts looking here. If they go to the recorder's office, they look here and above, because they're not going to keep looking after they got the property, right? They care about if the title is good here. And C at this point had not recorded. So we can't expect S to know. Now, if the facts had been a little bit different, and let's say that, so B gives to C, B gives to D, and then I'm trying to think of that won't work. Let's say B gives to C. C records. All right. Then B gives to D. Well, B is not going to be able to, D is not going to be able to argue that he did not have notice, because even if he didn't have actual notice, because he didn't actually know about this conveyance, he has constructive notice, because at the recorder's office, C had recorded their deed. And so had D done their due diligence and done a search right at this point, right here, they would have looked at B's title and they would have seen this. All right, this will probably all make more sense to you, but I wanted to talk about the diagramming in particular to try to make it clearer, because the only way it is clear to me when we're talking about notice states, because the question is about constructive notice, which means if you went to the title office and did a search at the time of the purchase, at the time of the conveyance, would you have been able to find the previous conveyance? And so to do that, I think it's easier if you kind of section off, because these systems use a grantor system, which means that you would have to look up, you would go to the recorder's office and you'd look up B's name and you would see all the conveyances B did. And then you'd look up C's name and see all the conveyances that they did. But you'd have to know to look up C's name. And you wouldn't know to look up C's name unless there was a recording that conveyed from B to C and you found it. All right. I hope that clears that up. Okay, I saw a question, so let me, the purpose of this, of doing it this way, was to be able to see, I think I can, nope, WebEx, expand, okay, now I see that in pink. Sorry guys. I don't know how to see the chats. Oh wait, just kidding, it is. Oh god. I appreciate you all being patient. I'm trying to figure out a way that I can share my screen, and okay, it looks like it's working finally. All right, caveat emptor versus the model rule in the video. Was the modern rule the majority rule that we utilize for the hypos? And the answer is yes. Hopefully I uploaded the correct video now. What had happened was I realized after I was so exhausted that I realized after I said it that I had incorrectly stated the majority rule. And so, but the thing about recording via Keynote is that you can't just go back and edit a part of it. So you have to delete everything up until that point. So I said, I'm just going to keep going and I'm going to learn how to use iMovie. And so I learned how to edit video, one of the many things I've learned this trimester. And I edited out and I re-recorded the audio there so it would have the correct rule. But then I guess I didn't know how to export it properly, and so it didn't export, and so I just had the old video and I uploaded the old video. So Anyway, thank you so much, Jacob, for catching that. And I think only 6 of you had seen the video at that point. So hopefully I didn't confuse too many of you. All right. Let's see, what else can I think of going over?
Hi, this is Io.
Hi, how are you doing? I think you were one of the folks that had seen the
Yeah.
yeah, sorry about that.
It's okay, you're fine. I was taking notes and I'm like, wait, this sounds weird, but I'm just gonna go with it. But that's all good. I was wondering if we could go over the assignment versus the sublease fee. I understand the difference between the two, but I get confused on who owes the landlord what.
Oh yeah, sure. That's a good question. Oops, did not mean to do that. Come back. Oh boy. I'm gonna get the hang of this, y'all. I will. Okay. So great question. So what is the difference between a lease, I'm sorry, a sublease and an assignment? Okay. So we said there are 2 types. There are 2 types of relationships that we have, right, when we're dealing with a lease. We have the privity of estate, and we have the privity of contract, right? And so you can think of privity of estate as property law before we started applying contracts to it, right? It is just rights and duties you get by nature of the estate of land that you have, right? So without a contractual agreement, you would still, to point to, you would still have certain rights and duties. So that's what the privity of estate is. The privity of contract are the rights and duties that you have vis-a-vis the contract that the parties entered into. Okay. So with a lease, you have a landlord that enters into a contract, and I use K to represent contracts. I don't know if that's just something that my own contracts professor did, or if everybody does that, but I use K. So the landlord entered into the contract with the tenant. Okay. So they entered into a contract, which means they have privity of contract. Now, the landlord also owes duties to the tenant based on the type of estate it is. And that is, it is going to be a term of years, right? Usually, or periodic tenancy. It's a non-freehold estate, right? So because there's a lease, there are some rights and duties that run with that. And what rights and duties are those? Well, one, you can try to think of it as what rights you would have just because you are in possession of the property. And so one right or one duty the tenant has, the major duty, the tenant has the duty to pay rent to the landlord. And that is based on the privity of estate, not the privity of contract. It might seem kind of weird because you agree in the contract as to the amount that gets paid. You agree that as to the type of tenancy that you're creating. So that's why I think it's confusing. But anything that touches the land is considered part of the privity of estate. Okay. And so it flows with the privity of estate. That's the major tenant duty. So there's a couple duties, right? So the tenant has to pay rent. They have to make sure that they don't commit waste, right? They can't damage the property. I'm trying to think. I think those are the primary ones. The landlord has duties too. these are duties. The landlord has duties too, and they owe an implied warranty of habitability. They owe some type of quiet, they provide quiet enjoyment of the land to the tenant. Okay. So these are, I think, the two major ones that we discussed. All right. So those are the privity of estate duties. So when we talk about the difference between a sublease and an assignee, the difference has to do with the fact that one of these two do not create a privity of estate with the landlord. They create the privity of estate with the tenant. So what do I mean by that? Okay, so let's say you have landlord and tenant. They have a 2-year agreement for lease. And so we have privity of estate and privity of contract here. Okay. The tenant, let's say it's a residential apartment, and the tenant decides they're going to do a year abroad. And so they go find somebody to sublease their furnished apartment. All right. But they only are going to be gone for a year. And so there will be a year left on the lease term. Okay. So the tenant is going to want to take the property back after a year. So they enter into an agreement with, let's say V, because we never use that one, with V. And you're trying to figure out if this is an assignment or a sublease. Well, first you figure out if it's an assignment or a sublease, and then that will tell you who owes what the duties. So you don't look to see who owes the duties to determine the relationship. You look instead to see how much of T's interest was transferred. And in particular, you look at the years. So let's say, so if we have 2 years and only 1 year is transferred, that means something else has to happen with that other year of the property, of the lease, right? And that's going to revert back to the tenant. And so in a case like this, you're going to have a sublease. And the reason you have a sublease is because T did not convey all of their interest to V. So because you have a sublease, you know some things about the relationships between these parties. Namely, you know, because you've identified this as a sublease, that V, privity of estate, is with T, as well as the privity of contract. That means that V owes T rent. And that then also means that T is not only on the hook for the contract, which T would always be on the hook as a guarantor, unless there's a novation, but T also has the privity of estate with the landlord, meaning T has to then pay the landlord rent, right? Because these are the duties. So T owes those duties to the landlord, V owes those duties to T. Now, alternatively, if we said that we have L and T and we had a 2-year T, so L and T, 2-year lease, and T decides that they are moving to Spain, okay? And so they're just going to try to find somebody to assign the lease to. Now, we're not going to call it a lease, an assignment, just because they use the word assign. We're calling it an assignment because T is conveying all of their interest to B. So in this case, since we know it's an assignment because all of this interest is transferred, we can then say what the relationships are between L and V and T and L. So we're always going to have privity of contract between these parties. Okay. But the privity of estate in this situation runs from the landlord to V. It means V must pay rent to the landlord owes these duties to V. T is just here hanging out as a guarantor. If V does not perform, T is on the hook. If V breaches any of their duties, what did I do? If V breaches any of their duties, then T is on the hook for it. All right, does that make sense? Did that answer your question?
Okay, so you said that if V breaks or breaches contract or whatever, then T would be on the hook for it?
Not breaches contract. If V breaches any of these covenants that run with the land, any of these promises, any of these duties that go with the privity of estate. Because remember, these are the privity of estate duties. If V breaches these duties, then T is on the hook for them. Because T is a guarantor. The question is, so why then do we have some of the cases that we have, right? Why does it even an issue if T? So let's say if T, okay, let me back up. So let's say that L wants to sue T because V did not perform. They can do that, but they also have to sue V if we have an assignment. And if they don't get it from V, then they can go to T, or T can try to get indemnified from V. Let's say instead we had a sublease, okay? If we had a sublease, we have the privity of estate running from L to T, so, and from V to T. So if V pays rent to T, then T pays rent to L, okay? And if V doesn't pay rent to T one month, that doesn't matter. T still has to pay to L. Well, what if T doesn't pay to L? L can only sue T. In this situation, L can sue V and L can go after T. But there is no relationship here between these two parties here that allows L to go after V. Additionally, let's say the landlord breaches their duties. So let's say the landlord breaches the implied warranty of habitability and the condo is uninhabitable. Well, the privity of estate in the sublease runs to the tenant. So the tenant is the V can sue the tenant, and then T would have to sue the landlord, right? V does not have any type of privity with the landlord, so V can't sue the landlord for performance. Does that answer your question a little bit more?
Yeah, that definitely helped. Thank you.
Okay, great question. One more question before we go. Any others? No. All right. Well, seeing as there are none, I am going to let you all go. I will hang out for a little bit if anybody wants to chat, but